Everybody, welcome to tonight's public lecture. Andrew Byrnes is no stranger to us here at Hong Kong U, and it's a great pleasure to have him back with us at the faculty, teaching an intensive course on the Human Rights Program, but also to speak with us and present his ongoing work. Andrew has a long history with us and the Center in particular. He was an associate professor of law and director of CCPL during his time here from 1989 to 2001. Whilst here, he served not only the university community, but also the broader community at large, particularly in his service in the drafting of the Hong Kong Bill of Rights and Equal Opportunities legislation in which he was closely involved. Presently, Andrew is Professor of Law and Chair of the Australian Human Rights Centre at the University of New South Wales in Australia. His work includes numerous publications on a broad range of areas, including gender and human rights, national human rights institutions, economic social rights, people's tribunals, and the incorporation of human rights in domestic law. Andrew has also served as the president of the Australian and New Zealand Society of International Law from 2009 to 2013, and has served in an advisory capacity to numerous bodies, including governmental and non-governmental organizations. Today, Andrew will speak to us on a subject that is a very live and hot issue. Various advocates around the world have called for an enhanced protection to address violence against women, but they differ on the question of whether we are in need of yet another United Nations treaty on the subject, and whether this is the best means to achieve this important goal. Andrew will speak to us for about 35 to 40 minutes, after which there will be plenty of time for questions and discussions. Please join me in extending a very warm welcome to Andrew. Thank you.
Thank you very much, Pooja, for that kind introduction. It's a great pleasure to be here, to be back here again. I come here occasionally, but not often enough. And I'd like particularly to thank the CCPL and also the Women's Studies Research Centre that is jointly hosting tonight's event. I had the privilege of being involved with both of those institutions when I was here, and it's great to see that they're still going. I suppose we could have some questions about a 20-year review of progress made around the institution. I see that many aspects of inclusion and diversity have appeared around the campus, from tactile footpaths to a range of things in the lifts, and it'd be good to see what progress has been made in other areas and what progress has been yet to make. Same sort of thing that we undertake at my current institution on a too infrequent basis. Thank you all for coming tonight on a fairly miserable winter's evening, although they haven't had as much rain, I think, as we've had in Sydney in the last day or so. And I fear that to draw on the metaphor, that some of my comments will actually be throwing a bit of cold water on some of the enthusiastic proposals in relation to a new treaty on violence against women. Not because I don't believe in human rights treaties, and not because I don't believe that violence against women and human rights is an issue that needs to be addressed, but really I have concerns about the way in which some of the debate is being constructed, the premises of some of the argument, and the analysis of the costs and benefits of the proposals that we've seen so far. But I should say at the outset that I certainly haven't made up my mind finally on whether or not one should go with it. But it seems to me that there are certain ways in which we might want to go about making that assessment that need to be added to the discussion so far. Let me start then with the June 2015 report of the then Special Rapporteur of the United Nations Human Rights Council on Violence Against Women, Professor Rashida Manjoo, a professor in law, an expert on human rights from the University of Cape Town in South Africa. In that report, one of her central recommendations, which reflected her 6 years of carrying out her mandate and extensive experience in the field, working with governments, NGOs, and others, the central part of that was the urging of the adoption of a new United Nations binding instrument on violence against women, accompanied by its own dedicated monitoring body. The call for a new treaty on violence against women is, as Pooja said, supported by a number of non-governmental organisations, many of whom I think have supported the Special Rapporteur in her work. It's not clear at this stage whether there is any governmental interest in or enthusiasm for moving such a proposal forward. My remarks this evening will examine this proposal, and in particular the way in which the argument for a new convention has been developed by Professor Manjoo and other proponents. A major plank of the argument for the new treaty has been the claim that there is a normative gap in international law relating to violence against women, and that that normative gap needs and can best be plugged by the development of a new binding treaty. The gist of the argument that I'll be making tonight is that the positing of a normative gap in order to strengthen the case for a treaty is potentially counterproductive. That is because the arguments that have been fought forward to support the claim there's such a normative gap give a misleading account of the current state of international law on the subject, have the potential to diminish or undermine the advances in international law made over the past 25 years, and distort the nature of the inquiry that we should be undertaking in deciding whether or not to support the development of a new convention. I don't propose to answer tonight, as I said, the question of whether we need a new convention on violence against women, but will focus primarily on the best way to go about deciding whether we do or not, and if we choose to go ahead, the way that we'll do it most effectively. I will, however, briefly consider what steps might be appropriate to strengthen the international law framework on the subject. I'll proceed in 5 steps. First, I'll very briefly note the continuing predominance of violence against women and the assumption that international law standards are a relevant and potentially useful tool in strengthening the battle against such violence. Secondly, I'll outline the manner in which Professor Manjoo and others have structured the debate over the need for a new convention, and will explore the importance of a notion of normative gap in international law for that argument, and the nature of the normative gap that is said to exist. Thirdly, I'll sketch the different types of convention that have been proposed, although at this stage it doesn't seem clear whether any particular model is seen as indispensable to the project, in particular whether a new treaty would contain substantive norms or be primarily or exclusively a procedural instrument. Fourthly, in order to assess the claim that a normative gap exists, I'll briefly review the current state of international law on state obligations in relation to violence against women, focusing particularly on the CEDAW Convention, the Convention on the Elimination of All Forms of Discrimination Against Women. But I'll also briefly refer to other treaties and to customary international law on the subject. Finally, I'll offer some thoughts on the drawbacks of persisting with an argument formulated in terms of normative gaps for the existing international law obliging states to address violence against women, and will suggest some of the issues that do need to be addressed more closely, as well as possible options for strengthening the international legal framework, while not undermining existing norms, institutions, and practices engaged in work in this field. So firstly, the persistence of violence against women and the relevance of international law. The starting point for my inquiry is the evident proposition, I think pretty uncontroversial, that violence against women in its myriad forms persists throughout the world, that many countries have inadequate national legal and other systems in place to prevent and address it, and even in those countries with strong domestic laws, violence continues to occur. In other words, there's an endemic problem with far-reaching human and social consequences that need increased efforts to address it. My second starting assumption is that international legal standards and obligations can play a positive role in efforts to eliminate violence. Of course, one must be careful not to exaggerate the impact of international law generally and human rights law in particular. A special fault, I think, occasionally of human rights advocates. Nevertheless, practical experience over the last 3 decades and the growing empirical social science research into the impact of human rights norms, including in relation to women's human rights, reassures us that belief in the actual and potential impact of international law is not, or perhaps not just, an article of faith, but has solid empirical support. The work of political scientist Beth Simmons stands out in this regard, but she is by no means the only scholar who's contributed to this body of scholarship. In short, we can assume that properly tailored and appropriately supported international norms and standards do have the potential to positively influence domestic practice in this area. Secondly, the types of conventions that have been proposed. Professor Manjoo has described the elements of the convention that she would like to see adopted in a number of ways. In general terms, she would like to see a convention that articulates violence against women, quote, as a human rights violation in and of itself, although she doesn't elaborate in great detail on what that means. It must be one that, quote, comprehensively addresses all forms of violence against women and clearly states the obligations of states to act with due diligence to eliminate violence against women. In addition to this general substantive content, Professor Manjoo also advocates that such a convention should have its own dedicated monitoring body. The role of this dedicated, specific monitoring body would be to provide substantive, in-depth analysis of both general and country-level developments. Professor Manjoo derives support for her argument for a new treaty from the development of regional treaties on the subject of violence against women. In particular, the Inter-American Convention on the subject, adopted in 1994, the Protocol to the African Charter on Human and People's Rights, adopted in 2003, and most recently, the Council of Europe Convention on Preventing and Combating Violence Against Women, adopted in 2011 and which entered into force in the last half of 2015, the so-called Istanbul Convention. It may be noted, however, that there is no regional convention dealing with the issue of discrimination against women which is equivalent to the CEDAW Convention on the UN level, in either the European, Inter-American or Inter-American regional systems. Within the African system, the provisions on violence against women are actually included in a CEDAW equivalent treaty, as the Maputo Protocol is a general treaty dealing with human rights of women in Africa, and it contains a number of provisions on violence against women. So we have a general description and we have some models out there ranging from relatively short conventions to a voluminous convention in the Istanbul Convention, which looks largely like a domestic criminal code in many respects. Thirdly, the structure of the argument. I think this is the central point. It's an issue which has also come up in the context of proposals for a new United Nations Convention on Ageing, in which advocates have gone looking for a normative gap on the basis that this is something that will help them overcome governmental resistance. Professor Manjoo's argument in relation to a normative gap, which draws on her extensive experience as UN Special Rapporteur and her other work in the field, is a clear and intuitively appealing one. It runs as follows. Firstly, violence against women is not explicitly covered by existing international treaty provisions. Secondly, international legal norms, new or supplementary, can potentially make an impact to the struggle to eliminate violence against women. And therefore, the adoption of a treaty which contains such norms would necessarily be a forward step in this goal. So put, the invocation of the normative gap theory has rhetorical power and seemingly makes strategic sense. Certainly it seeks to preempt governments from resisting proposals for new treaties by saying, well, there are plenty of norms, all we lack is effective implementation, the standard government response. At the same time, as I'll suggest, the concept of a normative gap is malleable and elusive, and its invocation not without problems. Well, what is this normative gap that has been identified? The gap is described in a number of ways. Firstly, as I mentioned, because there's no explicit reference to violence against women in the major UN human rights treaties, the phrase does not appear in the major UN treaty, the CEDAW Convention, which of course was adopted in 1979 at a time when violence against women was not mentioned as such on the international agenda. The same applies to the others. Thus, violence against women as a human rights violation in and of itself is not addressed by those treaties, goes the argument, and despite the existence of admittedly binding international obligations to eliminate discrimination against women, torture, or so on, which may incidentally address aspects of violence, there is, so the argument goes, no clear and explicit and comprehensive statement of the obligations of states to eliminate such violence. A second dimension of the normative gap focuses not so much on the inclusion of the concept of violence against women, but on the nature of the obligations, although those two are obviously related. Here, Professor Manjoo objects to the generality of such existing obligations as there are, maintaining that it's important to have detailed prescriptions of state obligations on this issue included in any treaty instrument. Binding generalities simply do not suffice to stimulate and support activities at the national level in a practical way. Of particular concern to Professor Manjoo in this context is one aspect of state obligations under international human rights treaties and international law more generally, namely the so-called obligation of due diligence, particularly in relation to violence against women. It's a topic on which she has contributed important insights in a number of her reports as Special Rapporteur, in particular in developing the notions of individual due diligence and due diligence, systemic due diligence. The notion of due diligence, which we know also from corporate law and now on the Ruggie principles on human rights and business, but traditionally it's one which is derived from classical international law of state responsibility relating to injuries done to foreigners. It has been transferred and applied in the context of international human rights law, and it concerns the obligations that states have to protect individuals against violations of their rights by other private persons, not by the state as such. The obligation is normally to take all appropriate or reasonable measures to prevent violations by private persons and to punish them when they are not prevented. While the state is not vicariously liable for the acts of private actors, it nonetheless may be liable for its failure to take reasonable steps to prevent or punish such acts. It's, I think, pretty clear that the obligation, the due diligence obligation of states in this area is of great importance, given that much of the violence that women experience is inflicted on them by private actors. The due diligence obligation should be contrasted with obligations binding on the state as such, state officials and the acts of the state itself. Generally, the actions of state officials are directly attributable to the state, and the state is strictly liable for them. So if a police official tortures a woman in detention, the state is responsible. The starting point of the inquiry is not whether the state has taken reasonable or appropriate measures to prevent the torture, the state is simply liable. Thus, the obligation on the state is higher than it is in relation to the prevention of torture by state acts than it is in relation to the prevention of violence or torture in the domestic context by a man against a partner or former partner. This is a distinction which is an important distinction that's often become muddled in some discussions of the topic of due diligence. But Professor Manjoo takes the view that there is no clear statement, no detailed statement of the obligation of due diligence in the international human rights treaties. To some extent, which is true. There is a statement in the Declaration on the Elimination of Violence Against Women, adopted in 1993, but the CEDAW Convention does not give a detailed, lengthy statement of everything a state must do in order to carry out its obligation. She considers that that would be one contribution that a new treaty might make, that it could include and define the contents of the due diligence obligation in relation to violence against women, will contribute to clearly stating the obligations of states to act with due diligence to eliminate that phenomenon. The third dimension of the normative gap argument focuses on the many international documents that have been developed over the last 3 decades. Violence against women, after all, has been on the international agenda for at least 25 to 30 years in terms of consideration by United Nations and equivalent bodies. The documents which have been adopted are the very important Declaration on the Elimination of Violence Against Women, adopted by the UN General Assembly in the mid-1990s. And in addition, there's been very important work done by the UN Committee on the Elimination of Discrimination Against Women, the monitoring body for the CEDAW Convention, which has adopted a number of what are called general recommendations, setting out what it considers to be the explicit and detailed obligations of states under that convention to take steps in relation to violence. Most important of those is one, some of you may know, called General Recommendation 19, adopted in 1992, which sets out the Committee's understanding of the coverage of the Convention in that area in relation to public and private violence, and goes through the Convention explaining what states should be doing. While Professor Manjoo recognises the importance of these documents and the detailed guidance they provide, her concern is their legal status. That is, they're not binding statements of international law as such. Declarations of the UN General Assembly, such as the one on violence against women, do not as such generally bind members of the United Nations under international law. Equally, the statements of the independent human rights treaty bodies, such as the Human Rights Committee, the UN, the CEDAW Committee, are not interpretations of the treaty's provisions that formally bind states as a matter of international law. They are obviously authoritative sources of guidance, and states are probably under a legal obligation to give them due consideration and weight. So Professor Manjoo argues, and I quote, "The current norms and standards within the United Nations systems emanate from soft law developments and are of persuasive value but are not legally binding. There are many soft law instruments that address the issue, including the Vienna Declaration and Programme of Action from 1993, Declaration on the Elimination of Violence Against Women, the Beijing Declaration and Platform for Action, and general comments and recommendations of treaty bodies. However, although soft laws may be influential in developing norms, their non-binding nature effectively means that states cannot be held responsible for violations." The non-binding nature effectively means that states cannot be held responsible for violations, she claims. Such an approach glosses over the considerable body of international relations and international legal scholarship and practice relating to soft law or informal norms, and the way in which such informal norms can directly influence state actions and indeed act as informal accountability mechanisms. Indeed, sometimes such informal norms, such as the Beijing Declaration and Platform for Action, for example, seem to influence states more than norms with formally higher binding legal status. But it's not my concern tonight to look at the strategies and the balance between formal and informal norms and lawmaking and soft law. My concern is really to examine the claims about the state of positive international law in classical international lawyerly analytical mode. So that's the argument. The treaty provisions, too general, don't explicitly address it. All these documents which do explicitly address it and give guidance, not really worth much because they're soft law. They don't bind, they're not an accountability mechanism. There's another potential source of binding international law, and that's the field of customary international law. Professor Manjoo also addresses that and argues that, so far as that goes, none of the soft law developments on violence against women has moved into the realm of customary international law as yet. Now, as I'm sure some of you know, to establish a rule of customary international law, you have to demonstrate by clear evidence general, widespread and consistent practice of states which supports the existence of the rule that you're claiming as a rule of customary international law. And that has to be accompanied by a sense of obligation. It's not an easy task. It's often the last refuge of the desperate advocate. And therefore one has some sympathy with Professor Manjoo not spending a great deal of time on this. Ironically, however, there's a strong and possibly compelling case to be made that of all the international norms relating to discrimination against women, the obligation to prevent, punish and provide reparation for violence against women by public and private actors might in fact constitute customary international law. A proper examination of that claim involves going well beyond the soft law documents that we've referred to and looking at their status, and requires a close examination of the widespread practice of states in various forums. And it seems to me, although I haven't done it, and one needs to be very careful about being too optimistic when looking for rules of customary law, that there is, I think, fairly good indication that one might be able to make that case. So ironically, in my view, Professor Manjoo may have been too quick to dismiss the possibility that obligations relating to violence against women do form part of customary law, that there might be some debate over the extent and detail of those obligations under customary law. At the same time, I think we must admit as a practical matter that working with a rule of customary international law is much more difficult in terms of persuading governments, courts, policymakers than it is when you're working with a clear statement in a treaty to which the state has subscribed. So in essence, that's the normative gap argument. No explicit and systematic reference to violence against women in the treaties, no customary international law obligation, no clear and detailed statement of a due diligence obligation in the treaties, and a plethora of useful and detailed soft law instruments which lack impact and relevance because of their status as non-binding documents. Accordingly, the argument then goes, the drafting of a new treaty that will remedy all of these limitations is a logical and practical necessity. I now turn to an assessment of these arguments more broadly. would suggest that the arguments put forward by Professor Manjoo and others oversimplify and thereby provide a potentially misleading account of international law and practice in this area. And as I've said, also downplay the significance of history and context and don't undertake an overall evaluation of the costs and benefits. None of these limitations in the arguments put forward thus far is necessarily fatal to the case for a new treaty. My argument is that such a case must be put differently and the direction of the inquiry changed if the gains that have been already made internationally are not to be diminished or undermined. Firstly, the international legal situation is, I think, more complicated than the analysis put forward by Professor Manjoo suggests. Indeed, I've already said that there are strong arguments, or some arguments for concluding there might be customary international law obligations on that, but I set that to one side. There are also, I think, powerful arguments for concluding that the international human rights treaties, in particular the CEDAW Convention, but also the others, do impose clear and detailed obligations on states parties in relation to the elimination of violence against women. Let me turn to the question of the binding obligations under the CEDAW Convention. Professor Manjoo notes, as I've mentioned, that the CEDAW Convention itself doesn't mention the words violence against women, doesn't contain detailed due diligence obligations, and she discounts the general recommendations and practice of the committee. Now, a conventional approach to the interpretation of a treaty such as the CEDAW Convention would go about things quite differently. Of course, we have to remember that conventions have a number of purposes. Of course, they're legal documents interpreted by international and domestic lawyers. They can be advocacy tools and rallying documents for people to use in their advocacy. They can be policy frameworks for those who are committed to implementing them. But the argument that I'm examining exists at that legal level. What does this treaty mean? Because that is the way in which the argument for a new treaty is being put. And a conventional approach to ascertaining the meaning of the CEDAW Convention would involve the accepted application of the rules normally used in international law treaty interpretation that's set out in the Vienna Convention on the Law of Treaties. And the starting point for those is the ordinary meaning of the terms of the treaty in their context in the light of the treaty's object and purpose. You can also take into account subsequent practice of states parties that establishes the meaning of the treaty and the drafting history in certain cases. As I'm sure many of you are aware, the CEDAW Convention imposes on states parties, or states parties accept under that convention, wide-ranging obligations under all fields of social life. Those obligations are, broadly speaking, to eliminate all forms of discrimination against women in those areas and to ensure that women enjoy human rights and fundamental freedoms generally, as well as in a number of specific areas on the basis of equality with men. In addition, Article 5 of the Convention requires states parties to take all appropriate measures to modify social and cultural patterns of behaviour in order to eliminate prejudices, customary or other practices which are based on the idea of the superiority of either sex or on stereotyped roles for men and women. The Convention requires states to ensure that state actions don't involve discrimination and that public officials do not engage in discriminatory acts. Equally importantly, the Convention explicitly obliges states parties to take all appropriate measures to eliminate discrimination by private persons. It says by, quote, any person, organisation or enterprise, end quote, and to modify existing laws, regulations, customs and practices which constitute discrimination, and to ensure that there is effective legal protection of women against any act of discrimination. To cut an even longer analysis of interpretation short, and it's available elsewhere, the critical issue is whether gender-based violence against women can be viewed as falling within the term discrimination against women, which is, after all, the explicit subject matter of the CEDAW Convention, or whether it falls within those notions about eliminating stereotypes in Article 5. It seems to me, as it has to many others, including states parties to the Convention, that this is in fact so. Discrimination, violence against women, gender-based violence against women, is a form of discrimination against women, for reasons that have been clearly set out by CEDAW and its pronouncements on the issue, which reflect broader understandings about the gendered power structures in society and the way in which they are reflected in violence against women. In effect, if you were an international lawyer in a foreign ministry carrying out an examination of your treaty obligation, which will probably generate the most narrow and least generous approach, the interpretation of the convention set out by CEDAW as applying to violence, imposing due diligence obligations in quite some detail, would in fact be the standard interpretation that would result from the application of those rules. Equally, the obligations of the state in relation to private parties, the so-called due diligence obligation, is clearly set out in Article 2 of the Convention, to take appropriate measures to eliminate discrimination by private parties. That applies also to discrimination against women, therefore violence against women committed by private actors, and its detailed content has been articulated by CEDAW in a range of documents, in particular its general recommendations. This understanding is confirmed by the practice of states parties to the Convention, of which there were 189 as of yesterday. As Professor Manjoo correctly points out, general recommendations do not of themselves have formal status as binding treaty interpretations, but that's not the end of the matter. States parties' responses to recommendations and the interpretive statements of such committees are of legal importance. So when CEDAW hands down a decision in an optional protocol complaint, when it concludes an inquiry, when it gives feedback to states after it's reviewed their reports, or when it adopts a general recommendation setting out its understanding of the meaning and content of the Convention, how states respond to that is relevant for what the correct interpretation of the treaty is. The Vienna Convention, once again, that guidebook on treaty interpretation, tells us that it's important for us to take into account in interpreting a treaty any subsequent practice in the application of the treaty which establishes the agreement of the parties to the treaty. And it's clear that state reactions to that are part of the relevant state practice. The practice has to be that of all the states parties, and it must establish the agreement of the parties. But the practice does not have to necessarily be active support, it may be tacit, as long as you don't have express objections. Now, there's much to be said in support of the position that the response of the 189 state parties over the last 36 years in the context of CEDAW does in fact, or last 30 years I guess does in fact support the position that they agree with the CEDAW interpretation of the Convention in all important respects. In order to definitively and scientifically answer this question, you would probably have to comprehensively examine a series of state reports from the beginning and state responses to CEDAW's pronouncement. One of our interns at the Australian Human Rights Centre, Erin O'Connor, undertook a sample study looking at the period 2010 to 2015, examining all the state reports, concluding observations, individual cases and responses by states to the committee to the committee's statement and their reaction to the committee's interpretation of violence against women. And what that showed, and admittedly it's a sample, is that they largely endorsed the approach taken by the committee. Many of them actively approved and supported General Recommendation 19. All of them reported in their reports on violence against women as falling within the scope of the Convention. None of them, so far as we were able to find in that period, and I suspect it goes back much further than 2010, none of them expressly objected to an interpretation of the committee saying that violence against women was covered, or to the committee's interpretation of the due diligence obligation. The only objections that we were able to find were in relation to some cases in which countries objected to the extraterritorial application of this obligation. So they argued unsuccessfully that they were not under an obligation not to refool or to return a woman to a country where she might be subject to violence. But otherwise, the only objections were not in the legal interpretation, but in the application to particular facts. So, in terms of an orthodox legal interpretation then, an examination of the words of the treaty and determinations in the context of its object and purpose, an examination of the practice of the under the treaty of states parties in responding to the interpretations put out by CEDAW, I think there's a very strong case that the situation is much more complex, that there is indeed clear obligations, that those obligations, while they might appear in the treaty at a general level, in fact have much more detailed content, which is not just soft law, which is not just recommendatory, but which has been accepted by the states to the treaty, who are the authoritative interpreters of the treaty, as extending to detailed types of measures that must be taken pursuant to these obligations. We might debate, I guess, how much detail, but it's clear, I think, that if one is looking at general recommendations on violence against women, that so much detail could be confidently accepted as falling within that obligation. So, where does that leave us? It's true that the 1979 Convention doesn't contain explicit and detailed definition of violence against women and a comprehensive list of specific steps that states should take. A CEDAW Convention drafted today, if such a thing were possible in the current political climate, might well contain something along those lines, although it's certainly not clear that it would contain the voluminous provisions that the Istanbul Convention contains. Despite that, as I've outlined, there's emerged over the last 30 years a detailed set of obligations accepted by states, accepted by governments, with impact at the domestic level relating to violence against women. And here I leave aside the many significant advances that have been made under other treaties, such as the ICCPR and also particularly the Convention Against Torture. The way it works is the stipulations are set out, have to read together the Convention's broad terms and the detailed content that emerges from the interaction between the CEDAW Committee and state parties through the engagement around the interpretive documents issued by the committee. So although it may be perhaps I'm not sure whether I undermine my argument that there is no normative gap by the time I've taken to demonstrate that there isn't. And you might say, well, it's all very well for international lawyers, but for the advocate, someone who wants to know where is the obligation, what we've got perhaps may not be enough. But it is certainly there as a matter of international law, and it's used all the time by the committee, by advocates around the world, by governments and others. So, if advocates of a new convention seek to argue there is a normative gap, that the detailed stipulations that we have are little more than moral exhortations to states parties, this is not an adequate exposition of the law, nor does it seem to represent an advance for those who are drawing on CEDAW as a source of binding legal standards at national contexts, however much it might be thought to strengthen the case for a new treaty. It would be a very unfortunate outcome of an endeavour to improve the situation in relation to the elimination of violence against women by strengthening the international framework if it were to undermine the accepted legal bindingness of those obligations and thus work based on them. Nonetheless, I think we can accept that further discussion about strengthening and refining the international legal framework and its more effective national implementation are very important. And we, I think, owe thanks to Professor Manjoo for raising this issue, which I think last arose in 1991 when similar arguments were had, and it was said we don't want to undermine the CEDAW Convention by having a new convention on violence against women, and as a result we ended up with the Special Rapporteur on violence against women, we ended up with an optional protocol to the CEDAW Convention, we ended up with a declaration on the elimination of violence against women and the Inter-American Convention on Violence Against Women. So in a sense you might say the argument has changed. We've now got more than we had then when the arguments were compelling. But Professor Manjoo has advised us or warned us we shouldn't get stuck in the past, we shouldn't just rehash old arguments, we should ask ourselves the question as to whether a new convention of some sort might actually add. We know from the experience of the Convention on the Rights of Persons with Disabilities and others that new conventions can have a mobilising and stimulating effect. They can draw in the community that is involved in advocating and formulating the convention. They can draw in new generations of advocates to whom the historical and rather arcane legal account that I've given is perhaps not known, not particularly exciting, not relevant. So there are those dimensions, as well as the legal analysis in terms of what a new convention might add. If this is so, and if we should approach the issue with open minds, how do we approach the question overall? What might such a convention usefully contain that would strengthen and not undermine? What are the implications of a potential new convention for the existing state of law and practice and the existing institutions? This is an inquiry which is yet to be undertaken in any depth, yet it seems critical from the legal, strategic and advocacy perspectives. What might there be? I think that it's important to look at the potential drawbacks, and I've alluded to some of them already. One is, of course, that if one now says that we need a new convention on violence against women because CEDAW does not cover it, that provides an interesting argument for governments who wish to exploit that opportunity. And it essentially undermines what has been done and would, I think, be deleterious. What advantages might we get? And what are the disadvantages? Well, the disadvantages that we might get are those that you get with any treaty, and one can probably discount them. One, you've got to get the political support, but if we said we're not going to do something because we haven't got political support, we wouldn't have the treaties and the advances we have now. What it also represents, though, and perhaps we can set this aside as well, is the deployment of significant resources over a period of years to move that process along. And then, of course, the process of ensuring the ratification by 189 states of such an instrument. The question is, would it be better to put those resources into the development and implementation of regional treaties or national level implementations rather than going for a new convention? But certainly some new instrument, some new interpretive mechanism would allow CEDAW to be updated. I mean, it's an old treaty. It's the creature of the 70s. We're now 40 years or more on. How do we update it? Well, one way to update it that has been suggested, in fact, is now in train, is for CEDAW itself, the CEDAW committee, to update its general recommendation. It is, in fact, working on it at this very moment to bring it into the 21st century to address some of the issues. The advantage that this has is it's flexible. It's not subject to the vagaries, political and otherwise, of an intergovernmental process. Once you put something in a treaty, it's not set in stone necessarily, but it can be hard to change. It doesn't give the forces of reaction the opportunity to try and dilute and undermine a broad definition of violence against women, which is a real political risk, I think, at the moment. It has the advantage of flexibility and updating. Of course, that's not necessarily an exclusive option. We have, after all, had parallel tracks. If we were to have a treaty, I think it would be very important probably to have something along a procedural line, perhaps a committee which might carry out functions of visiting and support, along the lines of the subcommittee on the prevention of torture, which visits in an educative and preventive capacity rather than in a reporting and or adjudicative capacity. That would be one option that's been suggested. It would seem that we already have a committee consisting of 23 members, the Committee on Elimination of Discrimination Against Women, which does a lot of this work. Do we need an additional committee? Where would the funds come from? All of that would need to be addressed. I think there are real dangers in going for a substantive convention unless it can be made very clear that any statement about the scope of obligations is purely confirmatory and affirming what is in CEDAW rather than seeking to supplement any deficiency or gap. So in short, in summary, I think that it's a very serious discussion that we need to have as to whether we can enhance existing protection by fine-tuning or supplementing the international mechanisms, substantively or procedurally. I think it's a serious mistake to pursue the normative gap argument too far. One, I think it's wrong. Two, I think it's strategically dangerous. But nonetheless, I think we need to shift our focus to a much more holistic and sophisticated analysis of what it means 40 years on from the convention with everything else we've got, to try and work with what we've got and to strengthen it and to not undermine or have an adverse impact on it.
Thank you very much, Andrew, for such a comprehensive treatment of this question. I should declare an interest. I've actually just today been asked to be a member of a drafting committee for producing a platform document which might feed into what such a future treaty might look like if these advocates sort of managed to push forward on this. And I think a lot of what you've said has really given me a lot of food for thought, and I think it's very, very important, and I agree for the most part with what you've said, that one should not undermine achievements that have already been made, which have been very hard won, and one should work in tandem with ongoing processes. So hopefully what this group of advocates is seeking to do won't undermine what has already been achieved. And I've already told them that we're having this discussion tonight and they'll be watching the video online. So hopefully there'll be lots of interesting discussion following on from that. We now have around half an hour for discussion time, so please feel free to raise your questions. It'd be good if you could please briefly introduce yourself before asking your question. Thank you. Yes, Simon.
Simon Young from this faculty. Andrew, you mentioned the optional protocol. Could that be a good way of implementing this rather than to have a separate treaty?
Look, to some extent, it depends what's in an optional protocol. I think originally Rashida was going for an independent convention, but I think she saw the force of the argument that you don't want to strike out, and she sees, I think, it as a concession that she's prepared to consider an optional protocol to the convention. Now, what's in it? If it's a substantive optional protocol, how do you put something in which doesn't undermine existing obligations? It may be possible. Or do you have a procedure? In which case, what sort of procedure do you have? Issues like, is it actually a subcommittee of the CEDAW committee? Do you keep the bodies aligned in membership to have a consistent interpretation, or do you, like the Torture Committee, have something called a subcommittee on which there are no members of the principal committee who are actually members of the subcommittee? It's all a bit unclear. I mean, these are the sorts of issues that I guess are going to come out in the wash. But it seems to me, that there was very strong arguments for saying it should be done as an optional protocol to the CEDAW Convention to present that united normative framework. But that does leave open options for different actors being involved.
Fazana Aslam from the faculty. Is there a downside, other than I completely understand your arguments around the normative gap, and I think those are points very well made, but what's the real downside for having a separate treaty that does acknowledge domestic violence as a distinct human rights gender-based issue?
I think ultimately if you were able just to amend the CEDAW Convention and put in a comprehensive definition and spell out the obligations in more detail and have the same community signed up to it, I think would be great. I think there is something said to be for specificity, although I must say I'm a bit concerned about the level of specificity that people seem to want in the treaty. If you look at something like the Istanbul Convention, which goes down to, factors to be taken into account in sentencing, and it goes to a level, so I'm surprised it worked in Europe, but it would certainly not at university. So I think you could do it. The question is how you get there and the arguments you get there with. So it's partly the resources argument. What do you work with? Is there an acceptance? I mean, I think there's something to be said for naming it and trying to formulate it. I think more work needs to be done on that. Getting there, how long is it going to take? Getting the ratifications can have upsides, they can have downsides, but I'm really more concerned about the potential for normative undermining, which doesn't exist in any of the regional treaties because they don't have a CEDAW equivalent that they have added this to. So it's really that integration. I don't want to be a stick in the mud because and say, we must stick with what we've got because we've got this terrific thing. It's a messy framework because it's an accretive framework. But a lot of international law is we make the progress around the margins through, and the role that these bodies have played, and the special rapporteurs is that sort of messiness. But we'll see. I just think that people have to be very careful, because not all the governments out there are friends, even if they might all say that they oppose violence against women. You start trying to define it in the terms that are set out in the Istanbul Convention, and it will be very interesting to see. Not sure if that answers it.
If I may take the liberty, I think one of the issues, of course, is the timing of this sort of push for a specific document on violence against women. Given that people have increasingly seen the uses of violence against women in particular contexts like political or warfare or situations of strife, and things, for example, that have been happening in India, or the awareness of the extent to which things and the level of brutality that has been happening is etched in people's minds, there seems to be sort of a search for something that positively helps address the extent of the problem. And so, for example, even in India, although we've had very proactive judges who have crafted very creatively out of existing laws sort of protections and imposed on the government certain obligations that aren't there on paper, people have found the CEDAW to be lacking in terms of how specific it is, in terms of exactly what the state is required to do. And I think to that end, perhaps, this is a call for something that can help operationalize some of those standards that the CEDAW committee is imposing on states. But there is this big gap between what they're sort of saying in their concluding observations and what advocates are seeing on the ground level. And perhaps it's a search for some narrative or some more clear legal basis.
It's an interesting concept that we respond in three levels to it. One is the international law, and the notion that the international law is going to go through. We all know the problems with that. Second is, I guess I'm a little surprised to hear that of India, because India, is classically cited as the example, controversial in terms of constitutional terms, in which the Supreme Court of India, famously in the Vishaka case, involving sexual harassment, more of a sexual violence against a government worker, said, India's party to the CEDAW Convention, and we are going to draw on CEDAW's General Recommendation 19, essentially to legislate. They adopted it as the implementation, the detail, and the constitutional standard until Parliament legislated. I don't think Parliament has yet legislated. So, clearly useful, and I'm sure it has penetrated the minds of Indian advocates who know this and who use this material. And so it seems to me one line of attack is to ensure that government officials and all those involved in it are aware of the additional material. And I know it's the case in the Australian government, the Australian Parliament, that when you're working with treaties, you're working with the whole of it, not just the bare text of the treaty. You've got this other material. So there's an educative process. But yes, I agree. If one had a statement, and perhaps the statement as a national level statement is easier to get than an international one. If you had an international one, perhaps, as I said, I'm not opposed to it. I think, there are, it's a many track approach, and a new treaty might be helpful, but there's a lot of other stuff that needs to be done as well, including using the existing resources and not dissing them in the way I think is being done.
Yes. Sorry, could you put on the mic so we can hear you, please?
My name is Crystal, and I'm a student at the Chinese University of Hong Kong. You referred to various international human rights treaties like the ICCPR and CEDAW. So my question is, to what extent would this proposed treaty borrow from international criminal law, if at all? And I ask because contemporary international criminal tribunals have considerably advanced protection on violence against women. So, for example, the International Criminal Tribunals for Rwanda and the former Yugoslavia has expanded the definition of enslavement, which previously was associated only with forced labor and servitude, to specifically include sexual slavery, following cases where women were found to have lived in conditions of enslavement, but provided predominantly sexual services. Also, the Rome Statute encompasses a broad spectrum of gender-based violence as crimes against humanity. So, to what extent could this proposed treaty borrow from these elements?
Well, the various bodies of law are obviously linked, and as I'm sure you know, international humanitarian law and human rights law apply the same stage. But so that, and there's been borrowing, as you know, each way between the various bodies of law. It seems to me your question raises the broader point, going back to Manjoo's argument about violence against women as a human rights violation in and of itself, in that how do we conceive of these different situations which are dealt with in a fragmented way, and I'm sure we're all aware of the argument is that, rather than dividing women's lives into times of peace and times of war, you're looking at a continuum in terms of experience of violence. And I suppose they would, the sorts of definitions you would expect if it were included would be the sort of thing that you have in the Inter-American Convention, which is a broad notion of, psychological, physical violence, which would apply to all those sorts of circumstances. But obviously it's a lower order. You're going to be hitting the violence against women threshold in many cases before you get to the war crimes or the crimes against humanity that you're referred to. But obviously they would be encompassed as well. In fact, they already are dealt with under the CEDAW Convention and the other human rights treaty bodies when they come within their jurisdiction. And of course, they're dealing with the responsibility of states, whereas the criminal tribunals are dealing with the criminal liability of individuals.
Michael.
So just going along with her argument there, it seems to me then maybe if you think CEDAW covers sort of the less egregious cases, some definition and some idea that every country has these obligations and they should enact laws and so on. So what Pooja brought up and what this last question brought up is more egregious violations. Maybe the avenue should be a protocol to the Rome Convention rather than to CEDAW, that maybe they should be looking at, because obviously these last couple of questions are getting at these really horrible kinds of things, and a lot of the rest of it is criminal law domestically in almost all countries. So, and CEDAW is putting a burden on them to report on how they're carrying out their obligations. But the real serious cases where women are in war and other things are being seriously abused seems to fall through the holes, through the cracks. Maybe it is the international criminal system and a protocol there that would be more effective.
Well, I guess it depends what the protocol will do. The crimes are there.
Yeah, but you're giving more definition to it, and you're creating an opportunity to arrest people and bring them to trial. You can have two tracks. You can also arrest them domestically, because that's what the Rome Convention says, that if they're prosecuted locally, then you don't have to go international. So,
look, once again, I'd maintain the position that the crimes are already there. Yeah, perhaps you could add them. You're talking about the International Criminal Court level. It's the fine points are really on issues which are not central to the definition of these crimes. I don't think there are other issues in terms of gender violence that probably need to be corrected. But I think that the issue, though, that you've raised two issues. One is, what do you do about states? And two, what do you do about individuals? In terms of states, of course, the human rights treaties, they work okay for states which are not in crisis, and who are reasonably prepared to engage, but it doesn't work for the breakup of the former Yugoslavia, for a while, it doesn't work for Syria, So, if there is a solution, it's either at the political level or perhaps before or after international criminal jurisdiction, if you believe in that. So it really then goes, in the International Criminal Court, is focused on individuals. Should you add states to it? You sort of have that combination of jurisdictions now in the African, in the African Union Court of Human Rights. They've added state responsibility and individual criminal responsibility together in one body. And would you do that? I mean, I think probably not. The notion of state crime and agreement would be problematic. The other issue then is really the perpetual conundrum of how do you get people who you might want to get before either a domestic court under a doctrine of complementarity or the International Criminal Court. And the answer there is not in definitions of violence against women. It's in those geopolitical and sovereignty-based factors that we see every day in the operation of the court, I think. So, yeah, not, perhaps, but not. I think the problems are more fundamental or different.
But I do want to go back to this question of definitions, Andrew. I think, although arguably you could find people liable under the existing sort of framework, I think that the burden then falls on the prosecution in any given jurisdiction, whether they see what has happened as something to be brought to account for before the courts. So, for example, in India, one of the issues was the type and nature of the rape committed had simply not been defined in that very form, and so they had to take steps to amend. So whether you could conduct a rape by instrument, for example. So, there are gaps there, and the question is, well, whose role is it, and where is it best addressed? Is it, domestically or internationally? And I do wonder whether what people are looking for now is greater specificity at that level, rather than leaving it to the states.
I guess I would still think that the process of domestic criminal law reform, yeah, I mean, in some cases, states may respond to the external approach. In other cases, they won't. And I mean, India seems to sort of flip-flop on some issues. But it seems to me that there are actually plenty of resources in terms of comparative law, in terms of international law, in terms of domestic constitutional values for that to be done. It's that it hasn't been is surprising, but criminal law develops at different rates in response to different things. So if you got a definition, would you get a definition which would descend to that level of specificity? I don't know, but where would you want to put your energy in terms of bringing about law reform? And obviously you have to make that assessment. I would have thought domestically, but I may be wrong. The other issue, I guess, is don't forget you're then dealing with 190 odd states. And if you want to go for a definition of sexual violence, I mean, one, you have the big issues. Rashida Manjoo seemed to be very keen on including economic violence, the old problem, if you discriminate against women in employment, it's economic violence. So everything becomes violence potentially. And there's obviously going to be a huge dispute over that. And I think one of the things that the wise Professor Savitri Gunasekara, the Sri Lankan former member of CEDAW, said, she said, look, one of the problems in separating out violence in this way is, one, you get those definitional issues, but two, violence has to be understood as an integrated part of a system of power structures that can be reflected in different forms of discrimination against women. And if you do see it, yes, as separate, but also as integrated, and that's the advantage, she argued, of the CEDAW Convention, then you get a better intellectual, you get a better contextual picture. Now that's the other side of, we need to name it, we need to separate it out, we need to define it so we know what we're fighting. And, I don't know, once you get a treaty and you define violence, if we defined it in 1979, would we have, sort of revenge porn and cyber stalking and other forms of violence? We also need to think, what's the best way to keep any treaty refreshed and up to date and flexible, and yet still normative and legitimate?
Well, this is why I asked the question, because going back to where you started, is it this which makes violence against women so endemic in all of our societies? What is it that, despite having this treaty framework which has recognized the oppression and the structures and how such violence is perpetuated, how is it that it is still endemic? How do you tackle that?
It's dismantling power structures.
Any other questions? Yes, Gina.
I have a question about the states that don't sign on to CEDAW. and whether a treaty that's separate from the CEDAW would be useful in the case of, let's say, the United States, which does not sign on to some of these other treaties, whether some other separate document that they could sign on to might be useful.
Yeah. Look, it's actually less of a problem with CEDAW than with some other treaties. I mean, I think the only two states that are still, I'm just trying to think who's left. I mean, the United States, and I think, is it Somalia? So it's a fairly small number. But, I mean, if it were the case that you had a particular norm that you could get agreement on, yes, but I don't know how important that would be in this particular case. I mean, I think if you look at the regional position in Latin America and in Council of Europe, I think not everyone has yet signed those conventions, but they're attractive because there isn't a CEDAW. They just have the General Human Rights Conventions, and therefore this is seen as something distinctive. Yeah, so I'm not sure. I need to think about that a bit more, but first sight, possibly not as strong a case as with some of the other treaties.
Yes. Just switch it on.
Actually, I'm thinking that you've got the Holy See as well hasn't ratified CEDAW. There are five, I think. Sorry, just to come back. I think there are five countries. The Holy See, I think, has not ratified. US. You probably have the others at your fingertip if you say. Yeah. So. Yeah. And so the question. I mean, those states are actually parties to at least some treaties which would cover violence against women already, whether they might not interpret particular acts as violence or things. But yeah, so, don't know. Yeah, I don't know how persuasive it would be geopolitically if you said, look, we must have this treaty because we want to get the US and the Holy See on side. But, you know, that's the politics of it, and who knows?
That's a lot of people who listen to these folks, you know.
Yeah, but then you've got to get them to ratify. Even the treaties which are specially designed and trimmed for them. But that's politics, and if it's something that's worth doing, then you do it despite the politics. You try and make the politics work for you.
You press the button in front of you, please. You've got to go deep so it goes red.
Can you? Oh, okay.
You're on.
I'm from the LM in human rights class, yeah. Actually, when it comes to this issue of like women's violence and like issues of women, the most recent issue came up with like this Beijing platform in 1995 is like the sexuality. I feel like we are going reversed because like even in Sri Lanka we have Domestic Violence Act. So violence against women, to a certain extent, we have addressed this through the General Comment 19 and with several other conventions. But I think from like very recently what we came up is that sexuality, like the positive aspect of being a woman. We always talk about violence and other negative aspect of being a woman. So we very recently we understood that part. Why don't we want a treaty with all of that, like the gender stereotypes and the sexuality? That sexuality, even that word is not in any of the conventions or any general comment. Sexuality means not the reproductive right, like being women and like to act as a woman. Sometimes men both have the same stereotypes of behaviors, things like that. And especially sexuality in especially in South Asia, in countries like us, like women cannot say, even in a family relationship, they cannot say that they want to have sex. If they say that, it considered as very bad as a woman. So that part we haven't touched up to now. So don't you think that we have to go more further when we talk about women's rights?
Take that as a comment, I think, but in terms of serenity, I mean, I don't see the two as necessarily mutually exclusive. I mean, what you're talking about are forms of violence, personal violence, okay, and presumably protected by law if marital rape is acceptable. So, I mean, it's in a sense it's part of a continuum, and how you address it is going to be a collection of strategies, you know, from the personal to the social and community, and societies and cultures change, and sometimes they change. Well, I mean, you know, don't need to tell you how they change as a result of push, and sometimes they're slow to change. And you know, Sri Lanka, like Australia, is an example of sometimes international standards can help drive domestic things, and sometimes they're seen as intrusive and produce a backlash. On the whole question of sexuality, obviously violence against women, this is understood as encompassing violence against women on the basis of their sexuality, although it may not be articulated as LGBT rights, but the broader issue of violence against LGBTI people, of course, is, you know, it's covered by the general human rights treaties, but you know how politically challenging that is in terms of the current UN discussions to get those rights recognised.
Right, I think that's all we have time for tonight. Thank you so much, Andrew, for indulging us and all our questions. It's been extremely fascinating discussion, and I hope that we'll still be seeing you and hearing from you on these issues in the years to come. Thank you once again.